Good afternoon, everyone. We're going to call the We're going to call to order the Children and Family Affairs Subcommittee. Haley, would you please call the roll?
Representatives Bricken, Eldridge, Farmer, Gillespie, Harris, Stewart, Chairman Littleton.
Here.
Madam Chair, you have a quorum.
Thank you. Do any of the members have any personal orders or welcomes or anything today? Seeing none, we'll start with a little housekeeping before we jump right into our calendar. By request of the sponsor, item number 7 has been rolled 1 week. By request, the sponsor of item number 8 has been rolled 1 week. By request of the sponsor, item number 6 has been rolled 1 week. So next we have item number 1, House Bill 2353 by Representative Garrett. Properly motioned and second, you are recognized. Well,
Thank you, Madam.
It looks like you have an amendment.
I do have an amendment.
And the drafting code is?
(014-263).
Properly motioned and second, and does it make the bill?
Yes, it does.
So let's get the amendment on the bill. All those in favor are put in Amendment 14263 on to House Bill 2353. Say aye. Aye. Those opposed, no. The ayes have it. You are recognized on House Bill 2353 as amended.
Thank you, Madam Chair and Committee. This is what has now become my annual trust legislation, the Tennessee Bankers Association.
The 3-minute trust?
Right, that's right. I'll probably be as fast as possible. I do this in my practice of law. The Tennessee Bankers Association has a division of lawyers that touches this legislation to make it the best that it can be. And so you can realize what they've done over the past several years. In the past 7 years, Tennessee has gone from having $25 billion in trust to over $200 billion. And the reason is that we touched this legislation to improve it. So with that explanation, Madam Chair, subject to any questions from the committee, I would like to move the amendment and move the bill.
I'm just going to move you right on out. No,
Try to be as quick as possible.
That's right. Are there any questions for the sponsor? Well, we've got a question here. Representative Stewart, you are recognized.
Just a brief question. Has the Bar Association's trust group weighed in on this?
Representative
Yes.
Garrett.
Thank you, Madam Chair. Yes, I believe so. They're in conjunction with the Tennessee Bar.
Representative Stewart.
Thank you for that.
Any other questions for Representative Garrett? Hearing none, are we ready to vote? All those in favor of moving House Bill 2353 out to civil full, say aye. Aye. Those opposed, no. The ayes have it. You move out to full.
Thank you, Madam Chair and Committee.
Thank you. Thank you for that timely explanation.
You're very welcome.
So next we have item number 2 by Representative Garrett. It's House Bill 2357. Properly motioned and second. You are recognized.
Thank you, Madam Chair and Committee. This legislation is brought to me by the Tennessee Bar Association through one of the judges in Chancery Court in Williamson County. And this is in a divorce petition. Actually, the judge, and I also practice in this arena, and one of the responsibilities of the judge when they look at a divorce situation is to make sure they attribute the marital estate. The marital estate includes the assets and the debts of the actual estate. They're supposed to be able to deal and split up equitably what assets are in the marital estate as long as whatever debts are also in the marital estate. However, since 2003 under case law, the judges did not have the actual statutory authority to separate the debt and equitably divide the debt, which they've been doing for 17 or 18 years. So what this legislation does is just codify what is known as common law under the judge law when they decide cases on appeal. So with that explanation, I'll be happy to take any questions.
Representative Brigham, you're recognized.
Just quickly, debts that are contracted debts, can the judge break those up?
You're recognized.
The judge won't necessarily break those up. The judge would classify that as either a separate debt of one of the parties or a marital debt as one of the parties. And when the judge decides what column goes with what husband or wife, depending upon who incurred the debt, is one of the factors the judge will decide on who is responsible for the debt. But that does not affect the creditors if both of them are on the debt. But the judge has to have the authority to assign that debt to one of the parties, whether he assigns it equally or wholly to one of the parties.
Representative Bricken. Any other questions? Hearing none, are we ready to vote? All those in favor of moving House Bill 2357 out to civil full, say aye. Aye. Those opposed, no. The ayes have it. You move out to full.
Thank you, Madam
very
Chair and
much.
Committee.
Next, we have item number 3 by Chairman Powers, House Bill 2623. You are recognized.
Thank you, Madam Chair and Committee.
Properly motioned and second.
Thank you.
It looks like you do have an amendment.
There is an amendment, 013721.
And does it make the bill?
The amendment makes the bill,
Does
yes.
it make, let's get, properly motioned and second. We're voting to put Amendment 13721 onto House Bill 2623. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Now you are on House Bill 2623 as amended.
Thank you, Madam Chair. Yes, under current law, grandparents and great-grandparents have the right to petition the court for visitation. Unfortunately, as we know, many marriages end up in divorce, and sometimes one parent or the other want to prevent some of the family members from visiting the children. And a lot of times it's been uncles or aunts or great-uncles or great-aunts that have actually pretty much raised the kids, and then all of a sudden they get cut off. So all we're trying to do is expand the definition for visitation rights to those groups, to aunts and uncles or great-aunts, great-uncles for the purpose of visitation, but they would still have to petition the court and get approval to do that. And so with that, Madam Chair, I renew my motion.
Are there any questions? Representative Bricken, you're recognized.
Thank you. And this might be a question for legal, but when I was researching not this bill but another bill, I found out in other state statutes they often use the definition of fifth-degree relationships, that kind of term, and I was wondering, does Tennessee use that type of blood relationship versus identifying the aunts, uncles, but the specific relationship? So, I mean, are we making, I'm just kind of curious, could we be more clarified if we went in that direction or not? So I'm not sure. Maybe I should have asked this outside committee, but just hit me.
Well, thank you. Representative Stewart is our legal advice on here. We might go to him for that particular answer, but I'm not familiar with the other states. Do you?
Representative Stewart?
Do you have a comment on that?
I was just looking it up, and I honestly don't know. I don't want to say because I don't know what the law is in other states on that, so I'm just not familiar with it.
Okay.
Chairman
That
Pat-
terminology, Representative Stewart, fifth degree, I haven't heard that either. Is that a legal?
I mean, it may well be a term that has legal significance in some other context in the state, but I couldn't vouch for it,
Okay.
honestly.
Chairman
And-
Paris, would you like to send that to us later?
Pardon?
If you can get that information,
I
would you
will.
send
I
that
will
to us?
send that to you
Okay.
later, yes. And if we get a subcommittee, I'll of course bring that to full committee too, and I'll look that up.
Are there any other questions?
No, that's fine.
Any more questions?
Okay.
Hearing none, are we ready to vote? All those in favor of House Bill, turn my page, House Bill 2623, moving out to full civil, say.
Sure.
Representative Stewart.
My question is, does any other state allow this? Is this something that's become commonplace? I remember with grandparent visitation, it was quite controversial.
It's still controversial.
Have any states expanded this like your bill would?
Well,
Chairman
we
Powers?
expand, I'm sorry, Madam Chair. We expanded it, a few years ago, and also included great-grandparents too at that time. And, but I'm not aware of any other states that have done that. We did expand it to that too.
Representative Stewart.
Okay, because I'm a little bit worried about it's a well-intended bill, obviously. I worry about the unintended consequences of just having a large number of new people that have the ability to assert family rights, is my concern.
But
Chairman
they
Powers?
would still have to, petition the court, and the court would have to agree to it at any point, yes.
Any other questions? So are we ready to vote? Hearing no objection, we'll be voting on House Bill 2623, moving out to civil full. All those in favor say aye. Those opposed, no? No. The ayes have it. You want to be recorded as a no, see the clerk, please.
Thank you, Madam Chair. Thank you, committee.
Okay, and as we all know, we're moving pretty fast in session, and Chairman Leatherwood is trying to be at 3 places at one time, so without objection, we're going to move him up to next. So we're going to move House Bill number 5, House Bill 2070. Properly motioned and second, you are recognized.
Thank you very much, Madam Chairman.
And you do have an amendment?
Is an amendment on the bill, 013303.
And does it make the bill?
It makes the bill.
Okay, so let's get the bill on. Properly motioned and second. All those in favor of Amendment 13303 going on to House Bill 2070, please say aye. Those opposed, no. The ayes have it. So you are recognized on House Bill 2070 as amended.
Thank you very much. And this legislation was brought to me by the Tennessee Bar Association, the group dealing with adoptions. And a lot of the bill is just cleanup activity, but some of it does add convictions for certain offenses to the definition of severe child abuse. So it would allow the judge to look at these offenses when determining parental rights.
Are there any questions for Chairman Leatherwood? Hearing none, are we ready to vote? All those in favor of House Bill 2070 moving out to civil full, say aye. Those opposed, no. The ayes have it.
Thank you very
Civil,
much.
yes. Try and just be 2 people next time. Next, we have item number 4, House Bill 1588 by Leader Camper.
Thank you, Madam Chair, committee.
We need a motion and a second. Second. Properly motioned and seconded. And I see that you have an amendment.
I do. Amendment number 014413. And it makes the bill.
Does it make the bill?
It does, yes, ma'am.
So let's get it in its proper. Let's get this one on first. Then okay. So all those in favor of Amendment 14413, say aye. Aye. All those opposed? The amendment's on. So, Leader Kemper, you're recognized
Thank
on
you,
the
Madam.
amendment. Hold on just a second. Representative Gillespie, did you have something?
Yes, ma'am, but I'm not sure what the procedure is for
I think
data.
it is an untimely amendment, right?
Yes, ma'am.
Is that what you want to put on?
Madam Chairman, I wish to make a motion to consider the untimely filed amendment.
Okay, so we'll be voting on consideration of an untimely amendment. All those in favor say aye.
I don't think we can get copies made.
Okay, well, so we're just taking into consideration the untimely amendment. So,
Okay, I don't.
excuse me, this is my first time to do this. So, all those in favor of accepting the untimely amendment, say aye. Or to consider the untimely amendment. And those opposed? No. The ayes have it. So you're recognized on the amendment. Y'all bear with me since it's my first time. Gillespie, you're recognized.
Thank you, Madam Chairman. What this amendment does, it just takes out in Section A, it defines specifically the family and household member in Part 2 of A as a current spouse, an adult or minor who currently lives with the respondent, or a person who is currently dating the respondent but does not include a person whose relationship with the respondent is limited to fraternization in a business or social context. D, a person who is engaged in a sexual relationship with the respondent. E, a person who's related to the respondent by blood or marriage. And F, a person who is related to the respondent by marriage. And then also in section, bear with me here, I'm sorry. Basically from the time that the judge orders the ex parte order from 14 days to 7 days. And that's basically what the amendment does.
Okay, are there any questions on the amendment? No questions on the amendment, so we'll be voting on the amendment to go on to Amendment 14413. Oh, I'm sorry, 14711. All right, so all those in favor of 14711 going on to House Bill 1588, say aye. Aye. Those opposed, no. The ayes have it. So, Leader Kemper, you are recognized on House Bill 1588 as amended.
Thank you, Madam Chair and members. I do see that as a friendly amendment. Thank you, Representative. I wasn't sure what the amendment was at the time, but I remember about the 7 days, so I thank you for that. I appreciate it. Members and Madam Chair, this bill is a piece of legislation we've been working on for a couple of years now in the previous posture, but we've been really working on this for a very long time. And so I think we're at a position right now where we can move this forward, particularly with the amendment he put on. It was brought to me by concerned citizens and constituents who are worried about family members who are in crisis that can pose threat to themselves or others. In past years, we've seen how challenges in the arena of mental health has been a concern, and with the pandemic and other stresses, we've really kind of seen an uptick in neighbors struggling with this. So this is not a novel piece of legislation. There's about 19 states in the District of Columbia who've already passed some extreme orders of protection type of laws. And we've also seen that with those laws, it has decreased the number of suicides. I know we have some people that on the list to testify, so I would yield at this point to allow them to give their testimony, and then I can come back, Madam Chair, if that's all right with you.
Yes, no, that is fine. We will go out of session to hear some testimony.
Yes, ma'am.
So we have three on the list. We have Tawana Chick, Elizabeth Harrigan, and Linda McFadden Ketchum. So if you three would come forward, please, and sit here. You'll each have 3 minutes apiece. So come forward and make sure the microphone's on and introduce yourselves and who you're with, please, for the record. So we'll just start and go down the line, and then we'll open up for questions. We can't have props. I'm sorry, they're not allowed. Just make sure the red light's on and the microphone is close to you, and we'll just start here and go around, and then we'll open it up for questions. And you each have 3 minutes.
Mother of three, he was diagnosed with narcissistic personality disorder with obsessive compulsive traits. Adrian overused his medications, became addicted to porn, ran up $60,000 of debt. He eventually lost his state job. He refused to accept that any part of his circumstance was his responsibility. On the way to a facility, he overdosed on meds. He came back and said again, nothing was wrong with him, it was everyone else. His wife finally filed for divorce. That same year, I retired from the Metro Police Department after a 28-year career that included receiving state-level awards for my work with mental health and domestic violence victims. I removed the guns from the wife's house at her request while he was in treatment. He wanted them back, but now he was threatening. His threats did not rise to the level of an order of protection. I notified the TBI. I asked them to not let him purchase more. They were not legally empowered to stop him or to check on his mental status. He bought more, including multiple assault rifles. He was then fired from 3 different trucking companies for accidents, tickets, and behavior over the next 3 years. He wrote his first suicide note sometime in that period, but we didn't know about that even though he was living with my mom and dad. He demanded mom and dad put their house in his name even though he was, again, not working. He built humongous fires next to my dad's log home. We later learned that he wrote another suicide note during this time. He began firing practice shots when I got home. I lived next door. I began living in fear due to his behaviors, but there was no clear threats that allowed any legal intervention. I discussed it with coworkers and counselors many times. We later learned that he told his children during this time, "I will not kill myself while you are still alive." He began sending text after text and screamed that we should put Dad's house in his name. He wasn't working again. He had massive debt again. On Monday, July 11th, he told my 85-year-old dad that he would burn both houses down and kill himself. We reported this assault by intimidation to the domestic violence unit. I made contact with the Tennessee Lawyers Assistance Program. We went to domestic violence on Wednesday and we met for 2 hours. Everything was in place to try to offer him help on Thursday. He wrote a suicide note that day also. Later Wednesday, I took mom out. She has dementia. Adrian started sending me strings of text messages. I could tell he had my dad cornered again. I took mom home. My dad was sitting on the porch, nearly crying because he had just suffered a berating and was unable to do much because he had hip replacement surgery just 4 days earlier. Adrian came outside wanting the house in his name. I told him, we'll talk about it later. He went in and came out again and yelled some more. The third time, he came out shooting. The first one struck me in my right ribs, through my lung and my liver. The second struck me across my chest. The third struck me in my right wrist, removing bone, artery, nerve, and tendons. I was moving, falling, rolling away quickly. I was hit 5 more times in my chest and my shoulder. I was hit in each leg. Both required skin grafts. The last shot was one he used in his own mouth less than 10 feet from my mom and dad. A red flag law might have helped. We'll never know. It would have been an awesome option for his 11, 14, and 16-year-old children and my mom and dad so that they didn't have to experience his death and my near death. We didn't have this legal option to try. We only had one flimsy assault by intimidation that would not allow for the removal of the guns. I was powerless over my brother. You have the power to empower our legal system in those special circumstances to keep our citizens safe by removing weapons. I deserved better, and so do all the other living and dead victims out there. This isn't about gun rights. It's about living rights. Please consider this red flag option. Only the state can provide this power. I'm still recovering, and I will be for life. I'm so very fortunate, blessed, lucky. Most victims are not. You can ask me anything. Thank you for your consideration.
Good afternoon, committee members. Can you hear me?
But can you introduce yourself?
Yes.
And who you're with for the record, please?
Yes. Elizabeth Harrigan. I'm a professional social worker, licensed clinical social worker here in Tennessee. And I come before you today in strong favor of this bill because in the 16 years that I've been serving Middle Tennessee in different roles and settings with different populations, I continue to see a need for an IRPO law in our state. I want to give you some examples that illustrate the need for this bill. Number one, a grandfather in his 80s had been experiencing symptoms of cognitive decline for a while. He was aging and he was in denial. His family attempted many times unsuccessfully to remove firearms from his home and from his possession, reached out to law enforcement for help. Unfortunately, the guns were owned legally and no crime was being committed. He eventually got so confused he attempted to shoot his wife in their home. Thankfully, she survived, and while he was hospitalized, his son removed the weapons. But 3 days later, he was discharged and he purchased more. Number two, a school counselor meets with a student, a 10-year-old girl, after learning that DCS visited her family home. The student tells the counselor that she is scared, parents are fighting more, dad lost his job, drinking all the time, says he cleaned up for the visit, but that days later she came home on the school bus to find him passed out on the couch and her 3-year-old sibling handling a loaded handgun. I'm going to skip the next one for time because I could go on and on forever. I could filibuster this. But I want to highlight what these situations have in common and why I think this legislation is important and safe. All of the at-risk individuals displayed, or that I listed, had an observable pattern of change in their behavior over time. And that behavior was known to increase a propensity for violence or harm to others. All initial measures failed. ERPO is not the first stop, it's the last stop, meaning all of these individuals were requested directly by family members, friends, professionals, or even agencies to engage in safe gun ownership, and they did not or could not. And probably the most difficult point and why I'm here today personally is that despite the aforementioned commonalities, the concerned parties were left only to wait for the worst to happen. And I want to tell you, the worst happens. It continues to happen. It happens every day. I have been here for 5 years talking about this bill. I am urging you to consider this. It saves lives. I am tired of feeling powerless as a professional, as a neighbor, as a mother, as a citizen when I see a train wreck coming and I know that I can stop it, but I'm not allowed to. I urge you to consider this bill. Thank you. And also invite questions.
I want to be sure that you all know that our first speaker was Sergeant Twana Chick, retired from Metro Police Department. I'm Linda McFadgen Ketchum with Moms Demand Action for Gun Sense in America, Tennessee. We are a gun safety and gun violence prevention organization. Our aim is to lower the death rate from shootings. We support legal gun ownership, training, the demonstration of competence, and proper storage. I want to talk about officer safety. Serving orders of protection, or ERPOs, is dangerous work. Because Indiana and Florida are similar to Tennessee and have ERPOs, we spoke with police officers and sheriff's deputies in those states. We wanted to know what officers on the ground are experiencing. Indiana has had an ERPO since 2005. Their ERPO is named for Officer Jake Laird. He was an Indianapolis police officer who was shot dead by a man who had just murdered his mother and was out on the street with a rifle. Before this happened, police had taken the man's firearms because of his mental health troubles, but he'd never been convicted of a crime, and so the police were compelled to return his guns upon his release from treatment. Otherwise, Jake Laird would not be dead. That's why the Indiana ERPO became law. Officers we spoke to in Indiana said none of them has been injured or killed while serving ERPOs. They told us they like the law because it keeps them safer. Florida passed an ERPO in 2018, just after the massacre at Marjorie Stoneman Douglas High School. Since that time, Florida officers have served 8,000 ERPOs. They do the research to find out what they may be running into when they're getting ready to serve it, and use that information to decide how many people they need to take with them. I asked one of the detectives who's handled about 400 of these if it's dangerous. She said, yes, it's dangerous, but you have time to plan and do the research to learn what you're dealing with. What's really dangerous is answering a 911 call when someone with a gun who shouldn't have one is shooting. Let's talk about suicide. 718 people die in our state from gun suicide. If we were to pass an ERPO and get the same reduction in suicide that Indiana and Connecticut have gotten, let's say 10%, that would mean 71 souls would still be alive instead of dead. I want to repeat that. Connecticut has experienced a 14% reduction rate in suicide. Indiana, 7.5%. So I went for 10%, thinking we could get that in our state, and that would save 71 people. When a gun is involved, 90% of attempts succeed. They end in death. Creating space between a suicidal person and their gun saves lives. And remember, this separation is temporary. When they are healthier, they will get their guns back. An ERPO for Tennessee is a big and a good idea. Our gun violence epidemic is big, and we need a big solution. If you get pushback at home, just say, I voted for this bill to keep 71 Tennessee women, men, and children alive, not dead. Thank you.
Thank all of you for being here. Are there any questions for our panel? Seeing none, now we'll hear from James Held from Safety. Thank you, ladies, for being here. If you could come forward and state your name and who you're with for the record, please.
Can everybody hear me okay? Just want to make sure. Okay, I think the mic's on now. James Held, Tennessee Department of Safety. Thank you, Madam Chair and members. We're not here to weigh in some of the philosophical one way or the other on this bill, but wanted to talk about some of the concerns the department has with the implementation of this legislation. As written, even with the amendments, the THP would still be considered a law enforcement agency under this bill, which would pose a few liability concerns for us because we would be required to have a policy whether or not we would have to file one of these orders or from one of our troopers. And even though it says in the bill it wouldn't be civilly liable, having that policy would potentially put us civilly liable if we decide or do not decide to file an order. And I know that the sponsor is mainly concerned about local law enforcement, but the as written, it would still potentially apply to us. That's also a concern when it comes to the supply of any firearms. If we have to keep them during the order for 14 days to a year, the department would have to have a storage facility for that and need to make sure that we're handling them without damaging them, depending on the value of the firearm. So those are our biggest concerns, and happy to answer any questions that the committee may have.
Thank you for being here. Are there any questions for Mr. Held? Seeing none. Thank you very much. Thank you. So we are now back in session. Leader Camper, you're recognized.
Thank you, Madam Chair, and I want to thank the people that came to testify. I appreciate your candor and honesty with the committee. And also, I've been trying to work with safety on this to amend them out. We talked about 2 hours ago, and I was not able to get an amendment to amend them out, and they were going to check with the higher-ups to make sure that if we amend them out, then they would be okay with the bill as it stood. And so what I've asked them to do is to allow us to move with the full committee, and then I'll work on the amendment, because I know committees are closing. I'd work on the amendment to amend THP out of it, and then if we can't come to some level of an agreement, then I would just park it there and not, because I don't want to put you all in a precarious situation. That's not the goal here. We want to really try to save lives. That's what we're trying to do with this bill. So I would hope that you all would support me in moving it to the full committee.
Are there any questions for Leader Camper? I'm going to take a personal moment and welcome Representative Andy Holt in the House. Glad to have you. I know. He did, didn't he? So there are no questions? So are we ready to vote? All right. All those in favor of sending House Bill 1588 to the civil full, say aye. Aye. Those opposed, no. No. Yeah. The noes have it. The bill fails. Thank you.
Thank you, Madam Chair, Committee.
And I think that concludes are there any announcements we need to make? Are we ready to adjourn? Oh, you're recognized,
I just want to
Chairman.
apologize for being tardy. I had a coughing fit or something happened to me in full, so I just had to eat a bunch of cough drops.
Yeah,
So
I
I want to
thought I was going to
apologize
have
for
to
that.
call an ambulance for you.
Yeah, me too. But I want to apologize to you and the members.
Thank you. So without objection, we are adjourned.